we are starting with torts. Okay, paper 2 torts. So before starting torts, I can tell you one thing, that it is not a very big section, but still a very important section. All right. So you have done your law from okay, Osmania University. It's in Hyderabad. Okay, all right. So it's completed 5 year or 3 year? 3 years. Okay, all right. So see here, we will be understanding the meaning of torts. Okay. हाँ ठीक है, सो उसको करेंगे हम, है ना, एक बार बताना आप, अभी तो ये नया सेक्शन स्टार्ट करते हैं, ठीक है। उसके बाद इफ यू आर नॉट एबल टू अंडरस्टैंड, उसमें क्वेश्चन को ना, सी व्हेन यू आर सीइंग वन क्वेश्चन, so the thing that you can do is to bifurcate that question, ठीक है। If you are, let's say, not able to understand the meaning of what the question is asking you exactly, what I have also seen is people like write something very different from what is asked. Okay, so don't do that. Break down the question into several parts and then just individually try to answer every part. Okay, and before writing, read your notes. Okay, तो उसमें से पढ़ो एक बार. See, there are two types of acts. Okay, for tort, so it is basically derived from a word that means twisted. Okay, tortium, that is twisted, something not right. Okay, something not correct. Okay, what happens is, so human civilization has already progressed from a very primitive state. What's your name? Satyashri. Okay, so Satyashri, one more student is there, that's Satya. Okay, so the thing is that since the very immemorial time, since a very primitive age, what human civilization has actually progressed. And with this progress, what has happened is there are certain codes that has been developed in the society, like some behavior. Okay, what, before coming to the class, you just said, sir, may I come in? Okay, you just asked me that, is this anything that is mentioned somewhere in any statute or something like that? No, not like that. Okay, it is basically generally accepted act. Even if you will not do that, then also it's okay, but in our society it's generally accepted as a correct way of doing this. Okay, now there are some established moral codes, or basically the legal codes in the society. Tort is something, tort is a particular act that is, I would say, a deviance from that particular set standard. That is somewhat deviance. It is deviance, and those deviances can be of two forms. Okay, let us first understand what are those two types of deviances. One deviances is particularly the act that we generally refer to as crime. Okay, what we generally refer to it as crime. Okay, now the another category of deviance of such act is basically considered to be as a civil wrong. What is the basic difference between these two acts? See, crime is an offense that is of a greater magnitude. For example, a person commits a crime, that is dacoity. Let's say he committed this. Okay, now A person plus B, using criminal conspiracy, they committed a dacoity, and which led to basically the loss of property of person X. Okay, now do you think this act was just a act that was committed against X? Yes, the personal losses were of X only, but the thing here is it disturbed the entire law and order in the society. It basically led to, are you able to understand? Are you getting? By your facial expression, I'm just like listening now, you're understanding now. So those acts are basically those acts which disturbs the entire society. For example, dacoity, criminal conspiracy, offenses against state, offenses against women, offenses against children. Okay, such offenses are basically considered to be as the offenses against the entire society, against the entire state, not just against that person. इसीलिए in those cases, when those cases reaches the court, it is basically X versus Union of India, X versus state. Okay, because in that case the offense was not just committed against that party, but it was committed against that state, against the entire community. Okay, because if this person is committing criminal conspiracy against X for the murder of X, these two persons can commit the same conspiracy against anyone in the society. they are basically referred to as a threat against the entire civilization or basically against the entire society. For example, the acts of terrorism, they are not a private act. If those terrorist organizations are basically killing the people of Kashmir, we cannot claim that they are just destroying the life of the people living in Kashmir, but actually they are the threat to the entire idea of India. They are a threat to India. Okay, so such are crimes. So this is a negative definition of tort. Okay, why negative definition? Because in explaining tort, we generally do not start with what exactly tort is, but we start with what tort not is. So the first thing I would tell is this is not tort. The first thing is this is not tort. Okay, why this is not tort? Because this is a particular crime which is committed against the entire state or society. All right. Now, if this is not taught, then what is taught? Okay. Now, the another thing that comes is, for example, I basically what I did it, I signed a contract with you. Let's say Satyashri, hai na? So I signed a contract with you. All right. Now I signed a contract with you, and the one term of that contract, or basically I signed contract with you, man. So now what happened in this case? Now there was one condition that I cannot do particular said X thing, okay, resultingly, which will lead to a wrong act. Okay, for example, I was not allowed to take a leave on Sunday, let's say. Okay, now I took a leave on Sunday. Okay, that was basically the violation of that contract. What was that? That was a violation of that contract. All right, now in this contract the harm has happened just to you. In case I violated this contract, the harm was limited to you both, because I signed a contract with you both. What will be the result of this violation of the contract? The result will be compensation. In case you will deduct my salary, you will not give me the payment that I was expecting to get. All right, this will also not be a tort. Reason I'm telling you, the reason is that in this case where a contract is signed, okay, in this case what will be the compensation or what will be the damages for this is basically written in the contract itself. The basically compensation for such harms is mentioned in the contract itself. In that case also it will not be categorized as tort. Now this is also not tort, where the damages are already fixed, where the damages are already liquidated. Okay, now what is tort? Another question is, now what is tort? See, sometimes what happens, there is a concept of trust. Okay, there is a concept of trust. Let's say X company is there, 1, 2, 3, 4, 5, 6. 6 people are collectively holding this particular trust. Okay, they are the trustees. This is the economic term basically. Now, in case this trust, any of the person of this trust breaches the trust of this particular organization, in that case also the damages or the compensation is liquidated. It is mentioned, let's say 3 just invested rupees 1000 in this trust, but is getting the profit of 20%, which was supposed to be 10%, so he took 10% extra, for which he will have to again pay the 10% back including fine. Okay, because in that case also the damages are liquidated, the damages are already mentioned, it is fixed. All right, now this is also not a tort. Now we got to understand one thing very clearly, that first thing, which is crime, is not a tort. Okay, second thing, a civil wrong, if in case of a contract or agreement, is not a tort. In case it is breach of trust, is not a tort. Every other civil offense amounting not to a criminal act, which is not a contract or breach of a contract or a breach of a trust, all those civil wrong are categorized as tort. Got the point? Able to understand this? So every civil wrong, which is not a breach of a contract, not a breach of a trust, or basically not a crime, which is an act against the society or the state, basically, except those civil wrongs, every other civil wrong is basically considered to be as a tort. How the questions are asked in your exam? It is basically, the question is are very simple from this topic. This is a completely static topic, very simple question. Like for example, there are two theories, okay, two major definitions, which are, one is given by Salmond, another one is by Winfield, okay. One very minor difference is there between those two definitions, all right. So from those definitions, indirectly the question can be asked, oh, okay. So there are some basically maxims. So from those maxims, the basic concept is asked, okay. So, and nature of tort is very important, because a direct question has already thrice been asked in UPSC exam from the nature of tort itself. Two times it was direct question, one time it was a bit, the line was very different, but the question was very same, okay, very similar to that, all right. So just so put the heading, that is torts, okay. So just put the heading, the law of torts. So right, as a my pattern is usually like this. I generally put very small question before writing anything. So just write, what is the meaning of a tort? What is the, not write a tort, because a tort and tort, the question in UPSC was asked on this also. Okay, what is the difference between tort, a tort, and laws of torts? Okay, so this was also a question. Whenever, like, the way we will progress in the chapter, we will get to know about what is the difference between these two terms. Okay, just write, what is the meaning of tort? Okay, now in this case, like in the case of crime, what you did is, you basically harmed the, I would say, the right of the state. Okay, the right of state is basically to maintain peace, order, tranquility in the society. Okay, we are harming this. But in case of tort, the liability arises by the violation of some personal right. Okay, some pride. Now for example, in the public sphere, I defamed someone. Okay, so the particular person was having the right to basically live with dignity. Now I hurted him. I basically, what I did, I defamed that person. His public image got defamed. In that case, it will amount to tort. Okay. For any other civil wrong, okay, which is not a crime. Okay. So right, the term tort is derived from the Latin word tortum. The word tort is derived from a Latin word tortum, meaning to twist, meaning to twist, twist, implying conduct that is crooked, implying conduct that is crooked, comma, wrongful or unlawful, wrongful or unlawful. Okay, right. So it refers to a civil wrong. It refers to a civil wrong where a person violates a legal right of another, leading to liability. And one very important point is, in case of, for example, there is a, मयंक की स्पीड बढ़ गई है ना. Earlier you used to write very slowly. You will also start writing fast. With me, everyone learns writing with a faster thing. Earlier, Pranjal also used to say this thing. Students are very busy in their prelims examination. They have to appear this year only. They're not coming actually. So earlier, Pranjal ही बोलती थी कि very fast. You are making us write too fast. Now I'm okay. So right. So the one basic idea is that, for example, there is a rape victim. Okay, so X person did a rape on Y lady. Okay, so in that case, because that's not a civil offense, because the injury that is inflicted in that case is not just on that lady, okay, because it's on this entire society. It's a blow to the entire societal values, okay. In that case, for example, the person X will say that let us settle this case and I will pay you 10 crore rupees, okay, for as a compensation, okay. In that case, that compensation can never be accepted. Why it can never be accepted? It can never be accepted because that was not a personal injury. That was not a injury inflicted against that lady only. That's an injury inflicted against the entire state. All right. So in that case, you cannot seek for compensation. So, but in case of torts, the remedy is usually compensation. All right. So, and you will now say that in case of crime, the provision of fine is also there. No, the provision of fine, the reason behind imposing the fine is very different from the reason behind imposing compensation. Okay, compensation is basically to remedify that particular injury that has happened. Okay, the objective of compensation is basically to fulfill the harm. Okay, but here the objective of fine is not to do that. Okay, so just write this. The law of tort is based on the principle that every person has a duty to respect the legal right of others. Every person has a duty to respect the legal right of others. Hmm. So everyone has the right, basically, that the legal right must be respected, okay, of everyone, okay. So now, right, when a person breaches this legal duty, the act becomes a tortious act. The act becomes a tortious act. Bracket में wrong है ना, something wrong, okay. And the injured party may claim compensation, what I just told you. And the injured party may claim compensation. Okay. Now, just I will make you write the difference between tort and other wrongs. Okay. Now, write a question. What is the difference between tort and other wrongs? Okay. So, there are many types of wrongs. For example, a crime is a wrong against the entire society. Okay. Uh, Basically, breach of contract is also a wrong only. Breach of trust is also a wrong. Okay. So, just put right in A, tort and crime. Here, right, tort crime is a right here, you need to do that. Okay, you can do that. Now in this here just write what I'm telling. Now here you can write tort and a breach of contract. Okay, so right, crime is a criminal wrong in which the duty towards the state or society is violated, and the remedy is punishment. In the bracket, write fine or imprisonment or both. And the party that brings action here is the state, but not the individual. Okay. Now coming on to tort, as I write, whereas tort is a civil wrong, whereas tort is a civil wrong, tort is a civil wrong where the duty towards the individual is violated, where the duty towards the individual is violated, and the remedy is in form of compensation, and the remedy is in form of compensation. Okay, what can be the remedy? The remedy is in bracket with compensation you can write damages also, because oftentimes the word damages is also used in the law of torts. Okay, and also you can write one thing: the party that brings the action is the injured party and not the state. The party that brings the action is the party that is injured and not the state. You have to appear in which year? 27. Okay, and what about GS? Okay, okay, from where? Wajiram. Okay, what's your timing there? 11 to 1:30. And this time is right for you or not? You're not getting time for lunch. Huh? Okay, not yet decided. Okay, all right. But yes, we generally conduct our class during this time only, mostly. Yeah, we can start if the demand is there, because last batch was the time for the last batch was I think 4 or 4:30 evening. But many students were demanding that we want our evening time for study. That's why we want afternoon. In the afternoon, the classes gets over. That's why we shifted the timing. Okay, so tort, now also write the difference between tort and breach of contract. Okay, between tort and breach of contract. Tort and breach of contract. Now, in case of tort, the duty that arises is because of a law. Okay, you're writing. Okay, right. In case of tort, the duty arises from the law itself. And in this case, the remedy is in form of, write one word, duty is remedy is in form of unliquidated damages. All right, unliquidated damages. What does that mean? That means the damages are not fixed. Bracket mein, write in bracket. The damages or compensation is not fixed under the agreement. Write the case of breach of contract. So, in case of breach of contract, from where the duty arises? Now tell me, from where the duty arises? In the breach of contract, from where the duty arises? In case agreement or contract is signed between A and B, so the duty is to follow that contract, and duty arises from that agreement itself. What have you written? Duty in case of breach of contract arises from the agreement between the parties. From the agreement between the parties. from the agreement between the parties. Okay. Now, in this case, what is the remedy? The remedy in case of breach of contract is usually predetermined. The remedy is usually predetermined or calculable damages. Calculable damages. All right. All right. So, in the case of breach of contract, let's say even if the exact amount of what should be the damage, even if it's not written, but the calculus is must have been there in the agreement itself. That, for example, the days you were not present, for those days into two, your salary will be deducted, or basically a formula must have been given in the agreement itself, which in case of violation of it will result into that compensation. All right. Now, one more, right, for this, don't make a table. Tort and breach of trust. But if you are you're continuing with table only, na? Continue with it. So, right, in case of tort, yeah, right, like this. A tort is, yeah, involves violation of general legal duties. Tort involves violation of general legal duties. Now write the another part, that is breach of trust. Whereas a breach of trust arises when a trustee arises arises when a trustee violates duties imposed by equity regarding property held for beneficiaries held for beneficiaries, right? Now, in case of trust, the property is basically held by those trustees. Okay, so the duty here basically arises when the person who is entitled in that particular trust, he basically breaches the norms of equity. Okay, like for example, 0.04% is your equity in that company. Now let's say, but if you breaches that particular equity, if you do anything that is antithetical to that equity norm, in that case, the damages because are already fixed in that case also. Okay, so that will be basically called as breach of trust. Okay, so that's the major difference between these. Okay, now because actually there is no as such universally accepted definition for this, or I would say even yes, universally, moreover is accepted. The definition of Salmon and Winfield is universally, not universally, but I would say moreover accepted by this legal profession. So I would say in this case we will accept those definitions also. One more definition is there, the Limitations Act of 1963. In that Limitations Act, Section 2, no, don't write, I will make you write everything, just understand. Okay, the Limitations Act of 1963, there is one section, that is Section 2 Clause M, that also provides a definition for what tort stands for, because that's a statutory definition. Okay, we will accept that also. Apart from that, Salmond has given one definition, Winfield has given, and Fraser's definition will be a add-on from my side, because in answer, basically every single person is writing the definition of Salmon and Winfield. I thought Fraser is also a very universally known or accepted jurist, so his definition must also be included in this. Okay, so just write what is then the definition of tort. Okay, what is the definition of tort? You know one thing there in British common law tradition, there were some writs of trespass, something like that. Okay, before tort. Okay, when the tort wasn't there, when there was no notion of tort at all that was present, there were some writ of trespass. Okay, or even there was something called as writ of trespass on the cases. Okay, so those were basically issued to the parties that you will follow this particular way and will not trespass to any particular place. Okay, you will not enter anywhere. Okay, you will not trespass the territory. So those things were there, but gradually, first came the writ of trespass, then came the writ of trespass in the cases. So after that, gradually entered the definition of particularly tort. Okay, so this tort definition also strengthened by after the definition given by Winfield. Okay, so just first right, Limitations Act, Limitation Act 1963. Section 2 clause in. Okay, right. Uh, Tort means a civil wrong. Tort means a civil wrong which is not exclusively a breach of contract or breach of trust. So, according to this definition is very simple and very straightforward, not very precise. I won't call this definition as being very precise because it leaves so many areas of tort without adding that into definition. But I would say, because this definition, you will notice one thing. This definition is not talking about what will be the compensation in that case or what will be the remedy in that case, because a proper definition is the definition that provides for the reasoning behind that, the types, and basically the remedy for that. Okay, that stands to be the proper definition. That will also help you whenever you basically find some particular definition. Try to write that definition that includes these three things. Okay, the nature, the types, and the remedy for that. Okay, so here, I would say this definition is not comprehensive and not precise, but still gives a very straightforward definition that it's a civil wrong that I made you understand in a few minutes of the starting of this lecture, that it is a civil wrong, it's not a crime, which is not a breach of contract or not a breach of trust. All right. Apart from that, any other civil wrong will amount to tort. All right. Now, write one more definition. That is the definition given by Salmond. That is the definition given by Salmond. Okay, so his definition is bit a more complex definition, right? A tort, a tort is a civil wrong for which the remedy, for which the remedy is a common law action, is a common law action for unliquidated damages, for unliquidated damages. Okay, very important to be noted here. Unliquidated damages, comma, and which is not exclusively a breach of contract, and which is not exclusively a breach of contract. And which is not exclusively a breach of contract, comma, breach of trust, or other equitable obligations. Other equitable or other equitable obligations. Important point here to be noted is he has expanded this definition which we earlier saw in Limitations Act. Here two more additions are there. It's a civil wrong, that's very right. It's not a breach of contract, it's not a breach of trust. One addition here is that it can be any other equitable obligation, okay? Any other similar obligation that is imposed on you, that you have the obligation not to harm in any financial way or any other way. It's my obligation that if the student is taking admission here, I must not basically, or this institute must not commit any such wrong that in turn impacts that particular student. Now, the thing here is, it has expanded this definition by including any other equitable obligation. Similar, any other obligation that is imposed on anyone. Harming that obligation will also amount to tort. One more thing here is the nature of the remedy of tort is unliquidated damages. Simple meaning of this unliquidated damages is it is not fixed prior, okay, not decided upon, all right, not basically thought upon before of the commission of this act. Okay, so this is the, so write one thing, the key elements of this definition is that point one, or write A, or even you can just put one arrow. Tort is a civil wrong. Tort is a civil wrong. Tort is a civil wrong. Second is remedy of unliquidated damages. Okay, remedy of unliquidated damages. And also one very important, not breach of contract or trust. Not a breach of contract or trust. Not a breach of contract or, ठीक है, clear? Any question? You're not asking question. He तो never ask question. Mayank understands everything. Huh? No question, nothing. Sometime he asks, sometime so he asks. You're not asking any question. Yes. You didn't find any question. You should find. You must bring question out of what I am teaching. Bring several. I basically enjoy addressing the questions. Okay. I enjoy that when students dig the ground very deep and bring questions. Okay. So, okay, when the time will progress, the questions might come. Okay. But write the definition of Winfield also. Winfield, one, I saw in my kitchen one day there was one baking soda of Winfield company. I don't know whether they got the name from this Winfield or only or not. But there was one baking soda of Winfield company. One custard powder also comes of Winfield company. So that Winfield only, okay? Right, Winfield. Where do you reside? Okay, in PG, Karol Bagh. All right. Winfield. All right. So tortious liability, right? Tortious liability. Tortious liability arises from the breach of, now very interesting thing. Every other definition talks about this is not breach of trust, this is not breach of basically contract, but he says it is breach of duty. Breach of duty. All right? Now, one interesting thing to, I don't know, this is the way how I learned. That's what I'm telling you. Uh, Here, win. Win feel. Win means win. That's the win of everyone. And when a person will win in life, when he will follow all his duties. So the duty word, duty dimension will come to win word. Okay. So then whenever win field definition comes, okay, just remember win, that means somewhere the definition will include breach of duty. Okay. This is how I learned, and till this date I can remember this like this only. When you will accidentally ask me, na, then what's the difference between definition of, then only at that time only I will relate. Okay, win, that means breach of, when will everyone win in life? Okay, they will win when they will follow their duty. Tortious liability arises from the breach of duty primarily fixed by law. Who fixes this duty? That duty that I just talked about, like when you entered the class, you just asked me, like, can I come in? Okay, so that was a duty, but not a duty put by law. General duty, which even someone will not even follow, that also is very much okay. Okay, but here the thing is, it is breach of a duty primarily. The word primarily is also there, because some duties are there you will have to follow. Okay, just utter some wrong things to your mother, you will get unlimited slaps. Okay, no, that is also a duty you will have to follow. Okay, Mayank, once try this. Okay, especially this is for boys, just give it a try. Now then you will come to your mother and will say this was not a duty fixed by law, why to follow this, then also she will tell you how to follow this. Okay, now coming on to point this, like again, so this duty from which, if you breaches that duty, due to which the tortious liability arises, that duty is primarily fixed by law. All right, now right comma, this duty is towards persons generally. This duty is towards persons generally, and its breach is, and its breach is redressable by an action for unliquidated damages. Redressable by an action for unliquidated damages.
सर एक क्वेश्चन
हाँ जी,
था मेरे को इसमें
हाँ।
तो सर वो आपने ब्रीच ऑफ ड्यूटी का जब एक्सप्लेनेशन दिया था तो आपने कहा था कि लॉ के अंडर में है ना उसको ये ड्यूटी परफॉर्म करने का रहता है तो इज इट लाइक कोई वो स्पेसिफिक ड्यूटी मतलब क्या कोई गवर्नमेंट जॉब या उसकी तरफ पॉइंट कर रहा है या कोई भी वो हो सकती है ड्यूटी
Every duty. Don't just talk about this breach of trust. Every duty it is talking about. It's the duty of a SHO to take immediate action in case he sees any kind of violence or any like disorder. But it's at the same time the duty of everyone to maintain peace and order. Every kind of duty it's talking about. It's a breach of duty that is primarily fixed by law. The law, even if doesn't explicitly says that you have to behave like this, but the law actually says that there must be peace, law and order, public order. That is also a duty. Okay, every type of duty. Clear?
हाँ सर और सर वो मतलब हमने सारी डेफिनेशंस में देखा था कि अनलिक्विडेटेड डैमेजेस की बात करते हैं तो मीन्स इट मतलब वो क्या टाइप का रहता है मतलब अनलिक्विडेटेड
हाँ जी, मैं
डैमेजेस
बता
का
रहा
अगर
हूँ,
एग्जांपल ले
अभी अभी बता रहा हूँ. And whenever anyone asks you, what, like, who will decide this unliquidated damages? Simple. It might be in form of forfeiture of property. It might be in form of paying the money as a form of compensation. It might be in form of again returning back the property that you have taken the occupation of, or any form of monetary related might be, है ना, or even the kinds में भी हो सकता है, it can mean kinds also. You understand Hindi? Understand well, very well. Okay, you are from Hyderabad only, then Hyderabad. Okay, I had been to Hyderabad. I stayed in one place nearby airport, Samshabad. It is there, no? One Geetam University is there, na? I visited that. Geetam University I went 2 times. So Hyderabad, one image is there of Hyderabad in media. By the media trial, we will read this topic also in contemporary legal issues. There is something called as media trial or trial by media. Okay, media before the judges, the media basically do the trial of everyone. Okay, now in trial of media, Hyderabad is a place where only riot happens. Okay, where only wrong thing happens. But just have a look at Hyderabad, yeah. This is amazing city. This is actually very developing city. It's a very fabulous city. One place is like thoda overburdened hai because population is more, but in New Hyderabad, it's like fabulous. So many flats, new IT sector that's emerging in Hyderabad. It's a very good place. There was a time when I was also planning to relocate to Hyderabad. I was very much impressed by that city. So unliquidated damages can be basically in form of providing, I would say, money to the person who is basically damaged, okay, who has suffered damages. All right, ठीक है? और कौन डिसाइड करेगा? Who will decide this? मयंक, कितना होगा डैमेज? How much will be the damage? Who will decide this?
Judiciary.
Don't say judiciary. Be a legal title. That is court of law. Okay, that is court of law. Why court of law seems to be some court of law? That's a more attractive word. Not, I'm just not saying this like this, but I'm very serious on putting emphasis on this. Right, court of law. Judiciary is a common word used by, you will say that you will see this like students of political science also, students of sociology also, students of every other field are using this very vague word, that is judiciary. You are a student of law, write the word court of law. All right, whenever Rajya Sabha comes na, don't write Rajya Sabha, because you are here preparing for law. No, your optional is law. That, see what happens, my advice always to whenever the students are in confusion that whether they must opt for law as their optional or not, what I tell them is basically, for example, like they are mostly confused in taking PSIR or law. So I would say when you will study PSIR or any other optional other than law, what will happen is basically 13,000 around students writes their mains examination. Your answer must be weighted. In GS, what will differentiate the papers of those selected candidates from the papers of those candidates who are not selected or who did not get good marks? So the only differentiation point is what extra things you are putting in, what what basically differentiating thing you are putting in your answers. Okay, that will just attract the examiner to reward you the better points. Okay, and that differentiating thing you can get in law. Okay, in law, you will be taught why particular things inserted, what's the significance behind these words. When you will study law, instead of writing Rajya Sabha, you will write Council of States only. It will be a practice that will inculcate in your mind when we will study constitutional law. We will never refer to it as Rajya Sabha, always referring it to as the House of People or basically Council of States. Okay, those differentiating points will come in your mind by studying law. Okay, दिखाना है खुद को, show yourself as a student of law, not a ordinary student. Okay, knowing law is in itself a very big thing. It's not a small thing, because majority of the people don't know law. They don't know law, and you know law. It's a very big differentiating thing. Okay, now fourth definition, right? Praiser definition. Praiser, FRASER, Praiser definition. Okay. Now Fraser introduced a very different dimension. Okay, there is something called as right in rem. He introduced this thing, right in rem. Okay, you as a individual, okay, have some right. No, you tell me what fundamental right is, positive or negative? No, that's not positive. That's negative. Why negative? If let's say I ask you to pick that pen up, that's positive. I'm asking you to do something. है ना? It's a general conception in our mind. The fundamental rights gives us something. No, they don't give us something. No single right is given to you. Why? I'm just telling you this. No single right and fundamental right is given to you. The right takes away the right of the state actually. Why? It acts negatively on the state because every line of fundamental right starts from the phrase state shall not. Just see the bare act of constitution. It says state shall not discriminate the people on the ground of religion, race, caste, place, sex, place of birth, right? It restricts the state. Okay, it is against the state, the powers of the state. Yes, now subsections are there which says the state that state must make special provisions for the upliftment of women and children. That is positive because the constitution is asking the state to do something, but in turn is actually limiting the powers of the state. Right in rem is similar to that only. Right in rem is that you as a person, you're sitting here in the class, you have this right that even you are sitting in your house, home, okay, you have a right against this entire world, that no one in this world can come and kill you, for example, or torture you, or provide damages to you, or defame you. Okay, you enjoy this thing, na? No one in the world must have this particular right to inflict any sort of injury on you. This right is called as right in rem. The right that we all enjoy against this entire world at large. Okay, this is negatively on working on. There is one proper saying also. Your right to use sword ends from where my nose begins. You can use your sword in whatever way you want, but you cannot inflict injury using that sword on my nose. Okay, your right to drive a car starts on road but ends the time where some other car is there parked in front of your car, because you cannot inflict injury on the another person or another's car, right? So that means, right, tort is an infringe. Now you have that right in rem. Okay, you have a right against entire world, that no one can harm any of your rights. Now Fraser says that tort is an infringement of a right in rem. Tort is an infringement of a right in rem of a private individual, giving a right of compensation, giving a right of compensation at a suit, at a suit of the injured party, of the injured party, of the injured party. That means when tort happens, some of your civil right gets injured. That means he termed that civil right as right in rem. Your right in rem got injured, okay, of a private individual, okay. Now you get one more right, that is the right of compensation. Now you become entitled to compensation. All right. What you got entitled to? Compensation. Okay. So that is one very important addition to this. All right. Now we derive something. So tort is a civil wrong. Not every civil wrong is a tort, because some civil wrong like breach of trust, breach of contract is not tort. Then comes breach of legal duty, which is fixed by law. Write these things, right? Now derived, what is now the right one question? Derived definition of tort, right? First derived definition, right? Tort is a civil wrong. Tort is a civil wrong. First, tort is a civil wrong. Right? Second, not every civil wrong is a tort. Not every civil wrong is a tort. Right? Next, breach of legal duty fixed by law. Breach of legal duty fixed by law. Right? Next, duty owned to persons generally. Duty owned to persons generally. Duty owned to persons generally. Right, next, remedy is unliquidated damages. Right, next, violation of a right in rem. Violation of a right in rem. Okay, so now the primary function of tort is what? It is basically loss distribution. The loss that has been incurred by the party in case the tort is committed, in that case the primary function is basically the loss distribution. Now one very important thing is it shifts the loss from the injured party to the person who is responsible. Now let's say a person inflicted damages on B. Okay, A basically damaged, है ना? What he did? Damaged, and B person is basically responsible for these damages. Now in this case, this B who suffered that, who is responsible for the damages, and this person who has suffered the damages, let's say the damages of 10,000 rupees. What tort do? Tort basically is shifts this loss of rupees 10,000 which has been incurred to this person. Now earlier it was on this person, it got shifted on this person. Now he will have to pay him this amount. It shifts the responsibility of these losses. All right, shifts. Okay. Now write as a question. Write one question. What is the social function of tort? Of tort law, right? What is the social function of tort law? The primary social function of tort law is loss distribution. The primary social function Exhausted writing. Oh, already written so many pages. How many pages? Still not exhausted writing. Now I'm understanding why I am having less capacity to write. I can't write more than 2 pages at one go. I feel so exhausted in writing. Mind you, इसको कुछ नहीं होता. He can write 10 pages, है ना?
हाँ सर.
एक दिन में तो जो है बोलने लगा था. One day I made him write so many pages, like around 7 to 8 pages. He was like next day, कल तो बहुत लिख लिया था. Yesterday we wrote too much, है ना? But on that day I compensated it, right? On that day I
Yeah.
compensated it. I did not made you write
हाँ सर,
anything.
वो
I gave
नेक्स्ट
you
डे
the
सर वो
PDF.
प्ली बार्गेनिंग का लेक्चर था, so
हाँ,
you
प्ली बार.
didn't made me write.
हाँ, है ना? So right. The primary social function of the tort law is loss distribution. The next point, right? Tort law aims to write like this. Tort law aims to writing is not good. Are you able to understand? So now this has already been expanded, but expansion is basically we will be writing in the next chapter. Now let us understand what is now. You tell me what is the difference between tort and a moral wrong? What's the difference between tort and a moral wrong? बताइए मयंक सर.
सर आई थिंक मॉरल रॉन्ग, आई थिंक थोड़ा वो उस पे आ जाता है, प्रिंसिपल्स
थोड़ा
के ऊपर
ज्यादा
आ
नहीं,
जाती है।
थोड़ा ज्यादा नहीं, स्ट्रेट डेफिनेशन बताओ।
आई थिंक मॉरल रॉन्ग
तो
डिपेंड्स ऑन द प्रिंसिपल्स।
व्हाट प्रिंसिपल? कुछ भी।
नो, जो नॉर्मल एथिक्स एथिक्स या मान लेते हैं, जो नॉर्मल एथिक्स होते हैं ह्यूमन बीइंग्स के।
और फिर टॉर्ट क्या है?
टॉर्ट तो सर सिविल रॉन्ग है।
अच्छा, टेल मी वन थिंग, टॉर्ट मस्ट बी व्हाट? इट मस्ट बी civil wrong, but what I'm trying to say is this is legal wrongfulness, right? What is the difference between, right? What is the difference between tort and a moral wrong? देखो, tort भी wrong है और moral wrong भी wrong है, ठीक है? But the thing here is, right, tort is often associated with wrongful conduct, but the wrongfulness is legal, but the wrongfulness is legal, not necessarily moral. ठीक है, right? Liability may arise from technical breach of legal duty even without any moral guilt. Liability may arise from technical breach of legal duty even without moral guilt. Clear? Any doubt? Read this once. पढ़ो इसको. Now write types of tortious liabilities. Just in the introduction we are writing this. Negligence, intentional tort, and strict liability. For this, any particular case law is actually not there. Okay, now the one question can be asked in your exam. The question can be, what are the essential characteristics of tort? Okay, in this case, we will be explaining this in the, like I will be explaining this in coming chapters also. So, but just to make you understand that it can be intentional, like for example, you are intentionally, deliberately, with intention doing some particular tort. That is, you are deliberately, for defamation, you are saying something that is intentional. Okay. Now, one can be negligence. It just happened. Okay. The tort just happened. Okay. You didn't did something, anything wrong in this, but it just happened by your negligence. Okay. You did something which you were not supposed to do. There is something, there is a phrase of a reasonable man. Okay, yeah, it is patriarchal, but a reasonable man, that means a person. I, because I have received those comments very often, I receive this, and because now Gen Z generation is coming, no, and Gen Z generation is very proactive in like provocating for this, kya bolte hain, feminism. Okay, so I also support that. That's why I clarify this thing. I know this is patriarchal, but this is a notion that the society is using. So a reasonable man. Okay, this is often a word you can read in various books. All right. So a reasonable person, society expects. All right. So if a person do not do any such thing which a reasonable person do, so at that time it is often referred to as negligence. Strict liability. You did something. You did not had any intention. You were fully constrained. You basically, you were the person who took care of every precaution. Still, because you committed this act, liability will be imposed. That's called as strict liability. Okay, so we'll be expanding this in the further classes, but a question can come. So I would like to, because this question is twice I have found this, okay, twice, and already we have discussed in brief, but now from onwards I will make you write every single element so that need not to ponder upon any notes or something like that, because I already told you 90% is class dictation, 10% is handouts. Okay, you will get the handouts only when it's necessary. Okay, if for example in only two cases, if time is short, any exam is approaching, time is short, or that basically don't doesn't happens because you, this is the right time for the student, because this is the coming sessions now, because between this month and for like more 2 more months admissions will happen. So this is the right time. Okay, so for 6 months we will be like continuing this course. I don't think time will be less, but in case I find something very factual or simply explanatory, in that case I provide handouts. All right, so this is a question that is usually asked: what are the essential, change the page, change the page badlo, page है ना. The one more thing I would suggest is, बताया होगा मैंने आपको भी मयंक, if let's say this is the page of your notebook, like you can do two things. Either you can leave some space here, okay, this space you can leave, or you can leave some space here. Okay, every alternate page, in every alternate, let's suppose this side or maybe that side, you can leave this section blank. All right, what you can do is, at the in the time to come, if you get anything in newspaper, let's say a quote of some like poet, or maybe a quote of some eminent jurist, or basically something said by any judge in delivering any judgment, all right, that you found it to be relevant, okay, you can simply write here. This is not a daily, like I would say a daily all catcher where you will have to daily ponder upon newspaper or something like that, but when you are simply reading the Hindu or Indian Express, you are reading something relevant to this topic, you can add on here. So that's why this space is left. All right, so you can do this also. Okay, so that's just my suggestion. Now let's start this question. Put a big heading, that is essential characteristics of Tort. So there are three essential characteristics. These are, just put these three essential characteristics in box. After that, one by one, we will be discussing every characteristic. All right. So the first characteristic of this, or make like this. Right. It is a civil wrong. These are the three essential characteristics. All right. Good. We try to make flow chart. What happens now? See, when you will just write these three lines, okay, that will be counted at as, for example, in this total 40 words are there. Okay. What happens now in mains answer when you will write your optional paper? So sometime, like just by my experience that I'm telling you, sometimes the mind hang. Okay. Uh, like actually, in reality, it hangs. Okay. What happens is we have a lot of information in our degree also, degree time also. We have gained a lot of information. All right. So during the time of these classes, we gain a lot of information by just referring to previous year questions. We gain a lot of information. There is no problem of information. What happens in that, during that 3 hours we need to process that information. That processing is a very bulky task. What happens sometimes, even if it's a very easy answer or an easy question, we are not able to process what to exactly write. In that case, if in case there is a shortfall of word limit, okay, you are just able to write only 200 words instead of 250 words. What you can do, one diagram, one this flow chart will compensate at least 40 to 50 words. You can avoid writing 40 to 50 words, instead of which if you will just make one diagram, that will compensate it. Okay, so diagrams are very helpful. Okay, especially for mains, when where, like, if you will take all the copies of a one student written during the mains paper, na, so that will basically, that can be published as an entire textbook. If you will collectively collect all those sheets, okay, of the mains answer, that can be published as a book. Okay, a book of encyclopedia covering every single topic. Okay, so like thinking is more difficult, okay, and putting everything what you know is even more difficult. In that case, sometimes what happens is you forget something for which you can use flowcharts. Okay, so inculcate this habit of writing, like making flowcharts. Okay, now put the first heading, that is tort as a civil wrong. You know this, right? A tort belongs to the category of a tort belongs to the category of civil wrong as opposed to criminal wrongs. सिविल रॉन्ग में क्या होता है, एक होता है प्लांटिव जिसको हम बोलते हैं इंजर्ड पार्टी, वन इज दिस प्लांटिव, ठीक है. सेकेंड थिंग विच इज देयर इज अनदर पार्टी इज defendant, okay, the person that defends, okay, himself or herself. And one more thing is remedy. Remedy, all right. So right, next point, in a civil wrong the injured party, in bracket write plaintiff, initiates the legal proceedings and the wrongdoer is called as defendant. And the primary remedy is damages, bracket में monetary compensation, bracket में damages bracket में monetary compensation, full stop, right? Yes, why not? The injured party, that is plaintiff, initiates the proceeding, okay. The wrongdoer is called as defendant, all right. And the primary remedy is damages, in bracket you can write monetary compensation, okay, monetary compensation, right. The objective is compensation to the injured party, objective is compensation to the injured party. All right, here. So time, and then some acts are actually, it's very much difficult to differentiate between whether the act was a civil wrong or a crime. Okay, sometimes this thing also happens. For that, I will make you write in the next class. All right. So, yes, that for that I'll have to basically. Hmm. Is it? Can you imagine something like a act which is a crime as well as a civil wrong? Hmm. Oh, just imagine one thing. Yes. For example, okay, what happened? A person, what he did, he at the night time he went to a main road, okay, and dug a very big hole on the road, okay. Now in the morning time, when a passerby was passing through that road, if a person fall inside that road, all right. In this case, two dimensions are there. One is public nuisance also was caused. Why? Public nuisance basically because it was a threat to others also. It was a threat to the entire society, entire people, everyone, whosoever was passing by that side. Okay. And also because A fallen inside that dig. caused a private injury to A also. In that case, he will be punished also because he created public nuisance, but will have to compensate also to A because the A got personal injury because of that person, right? So it is also sometimes very difficult to differentiate between what a civil wrong and a crime. All right.